Hi, my name is David Sampedro. I'm a board-certified civil trial attorney, Panter and Sampedro, and we handle all types of negligence and wrongful death cases caused by either other individuals or other corporations or companies. So oftentimes we're asked to look into wrongful death cases, and we're called by an array of people who may have close relationships with somebody who has passed away as a result of another person or another company's negligence or wrongdoing, wrongful conduct. There are some circumstances, however, that we cannot make a claim by law, even if there was negligence. So let's first talk a little bit about what type of claims that you can make. And let's keep in mind, for the most part, we're talking about here survivors. And survivors it's a term that's defined by Florida statute. Survivors typically are spouses. And when I say spouses, I mean legally married spouses. In other words, common law spouses are not recognized as survivors. In fact, common law marriage is no longer recognized in Florida since 1968. The other states are a little bit different. So spouses, minor children, and minor under the statute, the wrongful death statute, is actually children under the age of 25, not what you typically see with 18. Adult children, and blood relatives who are wholly or partly supported, economically supported by the decedent. That is, that the decedent provided them with either what they call support or services, and both of those terms are defined by Florida law. So all of those individuals under most circumstances can make a claim for economic damages. That is to say, whether it be the support and the services that were provided, or something that's called net accumulations, which is basically the money that is saved after one spends their income on general items on oneself. The other aspect of it is something called non-economic damages, or the pain and suffering damages, the loss of the companionship of the decedent. Under those circumstances, the only individuals who can make a claim in a wrongful death context are spouses, again, legally married spouses, minor children under the age of 25, the parents of the decedent, and the adult children. Now, there is a certain order in which those claims can be made. In other words, the spouse always has a right to make a claim. Minor children always have a right to make the claim. If you don't have a spouse or a minor child, the adult children can make a claim as well. And if none of those exist, then you can the parents can make a claim. Now, one of the exceptions is in the context of medical malpractice cases. In the medical malpractice cases, the only survivors who can make a claim for non-economic damages are spouses and minor children, children under the age of 25. So if you're over the age of 25 and your mother or father has died as a result of medical malpractice and you're over the age of 25, the law, unfortunately, regardless of how close a relationship you may have had with that person, does not recognize those damages that you have sustained, those non-economic damages that you've sustained, as compensable under Florida law. Similarly, if there are no survivors, if the decedent doesn't have anybody who is under the age of 25, in other words, if all of their children are adults, well, then under those circumstances, the law would not recognize those non-economic damages. So it's a lot to consider, and it's not always as easy as it appears, and there are a lot of nuances that you need to consider in the wrongful death context.